My name is Daniel Cross. I am 43 years old, and for 4 decades I believed my father loved me in the quiet, undemonstrative way some men do, through silence, through a firm handshake, through showing up. I was wrong. The call came on a Tuesday afternoon in March, while I was standing in the parking lot of my son's dentist office. The phone pressed against my ear so hard it left a mark. The voice on the other end belonged to a man named Gregory Feldstein, an estate attorney with an office in downtown Columbus that I had never once visited. He introduced himself carefully, the way people do when they know the next sentence is going to hurt someone. He said my father, Walter Cross, had passed away 6 days earlier. Not from illness, a stroke, sudden, in his sleep, in the house I grew up in, the house with the chipped blue mailbox and the maple tree in the backyard that I had climbed as a boy. Nobody had called me. Not my stepmother. Not my half-sister. 6 days, and I found out from a stranger holding a manila folder. I remember the smell of the dentist's office parking lot, hot asphalt, the chemical sweetness of a nearby car wash, because that smell is stitched to this memory now, permanently, the way certain smells attach themselves to certain wounds. Gregory's voice kept going, but I had stopped absorbing words. I caught fragments. Reading of the will. Next Thursday. Your presence isn't strictly necessary, but you're named, well, you're mentioned. Mentioned. Not named as a beneficiary. Mentioned, like a footnote, like something you'd bring up in passing and then move on from. I did not cry in that parking lot. I want to be honest about that, because I've noticed people expect tears in moments like this, and I didn't have any. What I had instead was a strange, cold clarity, like someone had reached into my chest and turned a dial from grief to arithmetic. 40 years. 40 years of Sunday phone calls, of driving 3 hours every Thanksgiving, of being the son who never missed a birthday card, and somehow I had been demoted to mentioned. Before I tell you what happened next, and before I get into exactly what was inside that manila folder Gregory Feldstein was holding when I finally sat down across from him, tell me, what time is it where you're watching from? Where are you watching from tonight? What's the weather like there? I'm always curious how far a story like this one travels, so drop it in the comments. I read every one. Now, back to where I was standing in that parking lot, phone in hand, a stranger's voice telling me my father had died 6 days ago and nobody had thought to tell me. To understand how a man could be erased from his father's final chapter, you have to go back. Not to the funeral. Not even to the will. You have to go back almost 20 years, to a woman named Carolyn Whitfield, who my father married 11 months after my mother's death from ovarian cancer. I was 23 then, freshly out of Ohio State with an accounting degree and a fear of being alone that I didn't fully understand until much later. My father was 51. Carol and was 44, recently divorced, and she came into our lives with a 15-year-old daughter named Bethany, a girl with sharp eyes and a talent for tears that arrived exactly when she needed them. I want to be fair here, because fairness matters to me, even now. Carol and was not cartoonishly cruel in those early years. She was, if anything, competent. She organized my father's medicine cabinet, coordinated his cardiologist appointments, kept the house cleaner than my mother ever had patience for. My father, a quiet man who had spent 30 years as a machinist at a plant outside Dayton, seemed to relax around her in a way grief had not allowed him to relax around anyone else. I told myself that was good. I told myself he deserved that. But there was a specific afternoon, maybe 8 months into the marriage, that I've replayed more times than I can count. We were at the kitchen table, the same table my mother had bought at an estate sale in 1987, oak, scarred on one corner from a dropped iron, and I mentioned, casually, that my mother used to keep her recipe box on the counter by the window. Carol Ann's face didn't change much. She just said, well, we don't really do that anymore, and got up to refill her coffee. My father didn't say anything. He just looked down at his plate. That was the first time I understood, on some pre-verbal level, that the house I grew up in was being quietly renovated, not with hammers, but with erasure, and that my father was either unwilling or unable to stop it. Bethany, for her part, was 7 years younger than me and treated our shared holidays like an audition. She called my father Dad within the first year, which stung more than I let on, and she had a way of positioning herself in every family photo so that she stood beside him while I stood beside whichever relative was closest. Small things. I told myself they were small things. I told myself that for almost 2 decades. There was a phone call, in 2009, that I still think about. My father had just been laid off, the plant was cutting back, and I offered to help with 2 months of mortgage payments, quietly, no strings, no mention to anyone else in the family. He accepted. He thanked me in a voice that cracked slightly, which was the closest my father ever came to open emotion. Carol Ann, I learned years later, told her sister at a Christmas party that the money had come from Walter's savings. Not from me. My name simply wasn't part of the story she told about our family, even when I was the reason the mortgage got paid. I kept showing up anyway. That's the part one need you to understand, because it matters for everything that comes after. I drove 3 hours every Thanksgiving from Cincinnati, where I'd built my career and my own family. I called my father every Sunday at 7 p.m., a ritual we'd kept since I was in college. I sent birthday cards to Bethany, even when she stopped sending them back. I told myself that love wasn't a ledger, that you didn't keep score with family, that eventually the small slights would stop mattering because blood was blood. I did not have a clean answer for why I kept trying. Even now, sitting across from a lawyer with a folder full of documents that would change everything I thought I understood about my father, I couldn't tell you exactly why 40 years of showing up hadn't been enough to earn a mention that wasn't just a footnote. What I did know, sitting in that parking lot with the smell of hot asphalt in my nose, was that Thursday was coming, and Gregory Feldstein's office was 3 hours away, and I intended to be in that room. The drive to Columbus took 3 hours and 11 minutes. I remember the exact time because I watched the dashboard clock more than I watched the road, as if arriving a minute later might change what waited for me. My wife, Renata, offered to come. I told her no, not yet, not until I knew what I was walking into. She packed me a thermos of coffee anyway and told me to call her the second I left Feldstein's office. I promised I would. Gregory Feldstein's office sat on the 4th floor of a converted brick building on East Broad Street, the kind of place with a brass nameplate and a receptionist named Diane who offered me water in a paper cup like it might soften whatever was coming. Feldstein himself was younger than I expected, maybe 50, with reading glasses pushed up into gray hair and a manner that suggested he'd delivered bad news in this room many times before and had learned to do it without flinching. He laid the folder on the desk between us and did not open it right away. "Mr. Cross," he said, "I want to walk you through this carefully, because I think there are some things you don't know, and some things that are going to be difficult regardless." The will, he explained, had been drafted on August 14, 2019, nearly 4 years before my father's death, and amended twice since, most recently on November 3 of last year, 4 months before he died. In the original 2019 version, I was named as an equal beneficiary alongside Bethany, splitting an estate that included the house, a modest 401k, and roughly $190,000 in savings and life insurance combined. That version, Feldstein said, no longer existed in any legal sense. The November amendment had removed my name entirely, redirecting the full estate, the house on Larchmere Drive, the $190,000, and a 2021 Ford Explorer, to Bethany Whitfield, now Bethany Cross, having legally taken my father's surname 2 years earlier. I was mentioned exactly once in the final document, in a single paragraph that read, "To my son Daniel, I leave my father's pocket watch, with love." I sat with that for a moment. A pocket watch. My grandfather's pocket watch, which I already owned a near-identical one to, because my father had given me a matching set for my 30th birthday. He had, in effect, willed me something I already possessed, while a woman who married into this family a decade after I was born inherited a house, a car, and nearly $200,000. "There's something else," Feldstein said, and this was the moment his voice changed register, became more careful. He explained that the November amendment had been notarized not at his office, but at a different practice, one belonging to an attorney named Rick Alvarez, who Feldstein knew only by reputation, and not a flattering one. Feldstein had only learned of the amendment when Alvarez's office forwarded the paperwork after my father's death, as protocol required. "I'll be honest with you," Feldstein said. "In 22 years of practice, I've seen maybe a dozen wills change this dramatically, this close to a client's death, using an outside notary the client had no prior relationship with. It's not illegal. But it's a pattern worth understanding before you decide what to do." I asked him what he meant by pattern. He hesitated, then told me that he'd requested my father's medical records be preserved, as a precaution, before I'd even asked. 6 weeks before the November amendment, my father had been hospitalized for 4 days at Mount Carmel East for what his chart listed as transient confusion, resolving. A mini-stroke. A warning shot nobody had told me about. That was the first rung of the ladder. I didn't know yet how many more there were. I called Feldstein's office again 8 days later, after I'd spent a week barely sleeping, running numbers in my head that didn't need running because they were already final. He'd done some digging on my behalf, he said, off the clock, because something about the case bothered him. He'd found a receipt among my father's things, a $4,200 check written to Rick Alvarez's firm, dated November 1st, 2 days before the amendment, memo line blank. And he'd found something else, 3 text messages, screenshotted and printed, apparently pulled from my father's phone by whoever had helped settle his affairs. Bethany, as it turned out, had been the one to go through the house first, before I'd even been told he'd died. The texts were between Bethany and Carol and, dated late October. I read them twice before I let myself believe them. Bethany had written, "He's getting confused again. This might be our only window before Daniel starts coming around more." Carol and had replied, "Don't push him too hard, we don't want anything that looks forced." Alvarez said keep it simple, one clean amendment. A third message, from Bethany, already told him Daniel hasn't called in months. He believed it. Didn't even question it. I sat in my car outside my own house, engine off, reading that last message maybe 15 times. Hasn't called in months. I had called my father every Sunday at 7 p.m. for years without missing more than a handful, and in his final weeks, someone had told him I'd gone silent, and he had believed it, because why wouldn't he? The people around him every day had no reason to lie, as far as he knew. I did not have a clean answer for what I felt in that moment. It wasn't only anger. There was something underneath it, quieter and worse, the fear that my father had died believing his son had abandoned him, when the opposite was true the entire time. 3 weeks after the reading, I drove back to Columbus, not to Feldstein's office this time, but to the house on Larchmere Drive, where Carol and still lived. I wasn't there to accuse anyone. I told myself that on the whole drive over. I was there to ask a single question, calmly, and to watch her face when she answered it. She opened the door in a cardigan I didn't recognize, her expression arranging itself into something practiced and sad before I'd even said a word. "Daniel," she said. "I'm so glad you came. I know the will is hard to understand, but your father wanted." "I called him every Sunday," I said. "For years." "Did you know that?" Something flickered across her face, gone almost as fast as it appeared. "I don't know what you're implying." "I'm not implying anything yet," I said. "I'm asking a question." She didn't answer it. She said my father's judgment near the end had been his own, that I was grieving and looking for someone to blame, and that I should let him rest instead of digging through his private decisions. Bethany appeared behind her in the hallway, arms crossed, and said nothing at all, which, somehow, told me more than anything Carolyn said. I left without raising my voice. I left without accusing them of anything I couldn't yet prove. But I drove home with Feldstein's phone number already pulled up on my screen, because I had stopped being a grieving son looking for closure, and started being something closer to an investigator looking for a case. Feldstein listened to everything I told him about the texts, the $4,200 check, the hospitalization records, and the conversation at the house, and when I finished, he was quiet for a moment before he said, "Daniel, I think you need someone who does contested estates full-time. This is bigger than a will reading now." He gave me the name of a woman named Priya Anand, a litigator in his building who specialized in undue influence cases, a legal term I hadn't known existed until that week, but which I would come to know intimately over the following months. Priya's office was smaller than Feldstein's, cluttered with case files stacked in towers along the walls, and she had a way of listening that made you feel like she was already 3 steps ahead, building the argument in her head while you were still telling her the facts. I brought her everything: the printed texts, the hospital records Feldstein had preserved, the $4,200 check, and a folder of my own phone records going back 6 years, which I'd requested from my carrier the day after I read those messages. 6 years of Sunday night calls, most of them 40 minutes or longer, every single one logged with a date and a timestamp that told a story Bethany's lie couldn't survive. "This is good," Priya said, tapping the phone records. "This alone undercuts their entire narrative. But we need more. Undue influence isn't just about proving someone lied, it's about proving your father's free will was substituted with someone else's intent, at a moment when he was vulnerable enough not to resist it. Under Ohio law," she explained, "a will contest built on undue influence generally needed to establish 4 things: that the testator was susceptible to influence, that the beneficiary had the opportunity to exert it, that they had a disposition to do so, and that the result, the will itself, showed clear signs of that influence." The transient confusion diagnosis covered susceptibility. The texts covered disposition. What we needed now was a clearer picture of opportunity, and of the amendment itself. That was when Priya subpoenaed Rick Alvarez's file on the November amendment, and what came back over the following 3 weeks built the second and third rungs of the ladder Feldstein had warned me about. The first rung, Alvarez's intake notes, dated October 29, showed my father arriving for the consultation not alone, but with Carol and present in the room for the entire meeting, a detail Alvarez's own notes flagged as unusual, since he typically preferred to meet testators privately to avoid exactly the appearance of influence. His notes read, in part, "Client's wife assisted in explaining family history. Client appeared to defer to her account of estrangement with son." Deferred. My father, a man who'd spent 30 years running a lathe with his own 2 hands and never deferred to anyone about anything, had deferred to Carol Ann's account of a relationship she had actively poisoned. The second rung came from banking records Priya subpoenaed from Huntington Bank, where my father had held his accounts for over 20 years. In the 6 weeks between the hospitalization and the amendment, 3 withdrawals had been made from his account, totaling $6,800, all in person, all requiring a signature. 2 of the 3 signatures, when compared against handwriting samples from earlier years, showed what Priya's forensic document examiner, a soft-spoken man named Arthur Kessling, who'd spent 31 years doing this kind of analysis for the county, described in his report as inconsistent stroke pressure and letter formation suggestive of physical assistance in signing, or diminished motor control at time of execution. In plain language, someone may have guided my father's hand. The third rung was the worst one, and it came almost by accident. Priya's paralegal was cross-referencing dates on the subpoenaed documents when she noticed something Alvarez's office had missed in its own disclosure, a scheduling note showing that Carol Ann had called Alvarez's office on October 22, a full week before my father's intake appointment, to discuss family estate planning options on her own, without my father present at all. The receptionist's note from that call read, "Caller asked about timeline for amending an existing will if the testator's capacity might be questioned later. Advised to proceed sooner rather than later." I read that line 4 times before I could speak. Carol Ann hadn't just taken advantage of an opportunity. She had asked the question herself, a week before my father ever walked into that office, about what would happen if his capacity was questioned later, as though she already knew, or already intended, that it would be. I remember calling Renata that night and telling her all of it, sitting on the edge of our bed with the lamp off, because somehow the dark made it easier to say out loud. She was quiet for a long time. Then she said, "Daniel, this isn't about the money anymore, is it?" It wasn't a question. She was right. Somewhere between the phone records and the receptionist's note, this had stopped being about the house on Larchmere Drive or the $190,000 or even the pocket watch. It had become about the fact that my father had died believing a lie about his own son, and I needed, more than I needed any inheritance, for that lie to be undone in a room where Carol and Bethany could not look away from it. Priya agreed to file a formal will contest in the Franklin County Probate Court. But before we filed, she made one more call, to a private investigator named Denise Okafor, who she'd worked with on similar cases before. "I want financials on Bethany specifically," Priya told her. "Debts, judgments, anything from the last 2 years." I didn't understand yet why that mattered. I would understand within 10 days. Denise's report landed in Priya's inbox on a Thursday morning, and Priya called me before I'd even finished my coffee. Bethany Cross, it turned out, had filed for personal bankruptcy protection 18 months earlier, listing $61,000 in credit card debt and a defaulted personal loan of $22,000, both undisclosed to my father, as far as any of us could tell. For months before the amendment, right around the time of the hospitalization, Bethany had also taken out a $15,000 loan against a vehicle title, a loan that remained unpaid. She needed money, Priya said simply. Not eventually. Now. That's your motive, on top of your opportunity and your disposition. That's the whole triangle, Daniel. I sat with the phone against my ear for a long moment, staring at nothing in particular. 40 years of Sunday calls, and it had come down to a woman drowning in debt, a hospitalization nobody told me about, and a receptionist's note about capacity being questioned later. I did not feel triumphant. I felt, if anything, a strange and heavy grief for my father, for the version of this family I'd spent decades pretending still existed, and for the fact that proving all of this in a courtroom would mean saying every ugly detail out loud, in front of people who had once sat across from me at Thanksgiving. But I told Priya to file. 2 weeks later, the probate court set a hearing date, and Rick Alvarez's office, along with Carol and Bethany, were formally notified that the November amendment was being contested on grounds of undue influence and lack of testamentary capacity. The hearing was set for the second week of September, 7 months after that phone call in the dentist's parking lot. In the time between filing and the hearing date, Priya prepared the way I imagine surgeons prepare, methodically, without wasted motion, treating every document like it might be the one detail that mattered most. We deposed Rick Alvarez in June. He was defensive from the first question, insisting he'd followed proper procedure, but under Priya's questioning about the October 22 phone call, the one where Carol asked about capacity being questioned later, a full week before my father ever set foot in his office, his answers grew shorter, his pauses longer. At one point his own attorney asked for a 5-minute break. We deposed Carol in July, in a conference room at Priya's office with a court reporter typing quietly in the corner. She wore the same practiced sadness she'd worn at the front door of the house on Larchmere Drive, but Priya didn't raise her voice once. She simply laid out the timeline, document by document, the hospitalization, the phone call to Alvarez's office a week before the intake appointment, the withdrawal signatures Arthur Kessling had flagged, the texts to Bethany about the window before I started coming around more. Carol Ann's answers grew evasive, then contradictory. At one point she claimed she couldn't recall calling Alvarez's office at all, and Priya simply slid the receptionist's note across the table and asked her to read it aloud. She did not read it aloud. She asked for water instead. Bethany's deposition was scheduled for August, but 3 days before it was set to happen, her attorney contacted Priya requesting a settlement conversation instead. Priya told me this was common, that people who know their story won't survive cross-examination often try to negotiate their way out of having to tell it under oath. I told Priya I didn't want a quiet settlement. I wanted the truth said out loud, in a room where it could not be walked back later. Priya respected that, though she warned me it would cost more, take longer, and offer no guarantee of a cleaner outcome than a negotiated one. I told her I understood. I meant it. The hearing itself took place in courtroom 4B of the Franklin County Probate Court, in front of Judge Miriam Castellano, a woman in her 60s with silver hair pulled back tightly and a reputation, Priya told me, for having no patience for theatrics and enormous patience for documentation. I sat at the plaintiff's table in a gray suit I hadn't worn since my father's funeral, which I had, by then, attended without ever being told the date in advance by anyone in that family. I'd learned it from an obituary posted online 3 days after the fact. Carolyn and Bethany sat across the aisle with their attorney, a heavy-set man named Foster Trammell who kept glancing at his watch as though this were an inconvenience rather than a reckoning. My stepmother did not look at me once during opening statements. Priya built her case the way she'd built it for me in her office, months earlier, brick by brick, document by document, refusing to let a single claim stand without paper behind it. She entered the hospitalization records first, then the phone call log from October 22, then Arthur Kessling's forensic analysis of the withdrawal signatures. When she reached the text messages, she had them blown up and projected onto a screen mounted on the courtroom wall, Bethany's own words displayed in black and white for the entire room to read. "He's getting confused again, this might be our only window." I watched Bethany's face when those words appeared. She looked, for the first time since I'd known her, genuinely afraid. Trammell objected to the admissibility of the texts, arguing they'd been obtained without proper chain of custody, since Feldstein had found them among my father's effects rather than pulling them directly from a device. Judge Castellano allowed a brief sidebar, then ruled the texts admissible, noting for the record that Feldstein's preservation of the phone had been prompt and documented, and that the messages corroborated independently with the banking and legal records already entered. Trammell sat back down without another word. Then Priya called Bethany to the stand. "I want to describe this carefully, because it is the moment everything in this story had been building toward, and I don't want to embellish it, the truth needed no embellishing." Priya asked Bethany, calmly, whether she had told my father that I hadn't called him in months. Bethany hesitated, glanced at Trammell, then said, "I don't specifically recall saying that." Priya asked her to read her own text message aloud, the one on the screen behind her. Bethany read it in a voice that had lost all its earlier composure. "Already told him Daniel hasn't called in months." He believed it. "Was that true?" Priya asked. Had Daniel stopped calling his father? Bethany didn't answer right away. Priya entered my phone records into evidence, 6 years of Sunday calls, 40 minutes on average, the most recent one logged 4 days before my father's stroke. According to these records, Priya said, Daniel called his father every single Sunday for 6 years, including the week before he died. "Is that consistent with what you told your stepfather?" "No," Bethany said, so quietly the court reporter asked her to repeat it. "No, it's not." I did not feel victorious in that moment. I want to be honest about that too, because I think it matters more than a tidy ending would. I felt something closer to nausea, watching a 29-year-old woman unravel in a courtroom over a lie that had cost my father his last clear understanding of who loved him. There was no satisfaction in it, only a kind of exhausted, aching confirmation of something I had already known in my body for months. Carolyn took the stand after her, and her testimony collapsed faster than Bethany's had, because she had less practice lying under this kind of pressure. When Priya asked why she had called Rick Alvarez's office a week before my father's own intake appointment to ask about capacity being questioned later, Carol Ann's composure finally broke. "I was protecting this family," she said, her voice rising for the first time. "Walter wanted this. He wanted Bethany taken care of. Daniel had his own life, his own money, he didn't need." "That's not what's being asked," Priya said, quietly, cutting through the deflection without raising her own voice at all. "The question is whether you initiated contact with an attorney about capacity issues before your husband ever expressed any intent to change his will. Yes or no?" Carolyn didn't answer for a long moment. Then she said, "Yes," and something in the room seemed to exhale all at once, as if everyone present had been holding the same breath. Judge Castellano took a 10-day recess before issuing her ruling, which she delivered in writing rather than from the bench. I read it standing in Priya's office, my hands not quite steady on the pages. The court found clear and convincing evidence of undue influence in the execution of the November 3rd Amendment, invalidating it in full and reinstating the original 2019 will, under which the estate was divided equally between Bethany and myself. The court further referred the matter of the $6,800 in questionable withdrawals to the Franklin County Prosecutor's Office for review, and noted in its findings that Rick Alvarez's handling of the intake meeting with Carol and present for a private capacity assessment fell below the standard of care expected in estate matters, a finding later forwarded to the Ohio State Bar Association for its own review. The consequences, once the ruling landed, arrived in pieces over the following months, and I want to lay them out plainly, because vague justice never felt like justice to me, only specifics ever did. The Franklin County Prosecutor's Office reviewed the $6,800 in questionable withdrawals and, after an 8-week investigation, declined to pursue criminal charges against Carol and directly, citing insufficient evidence to prove beyond reasonable doubt that she had physically guided my father's hand rather than simply been present when he signed. It was a disappointment, though not a surprising one. Priya had warned me from the start that criminal financial exploitation cases involving elderly victims were notoriously hard to prove, especially when the victim was no longer alive to testify. But the probate ruling stood regardless, and that ruling was where the real consequences lived. The November amendment was voided in full. The original 2019 will was reinstated, and under its terms, the estate, the house on Larchmere Drive, the $190,000 in savings and life insurance, and the Ford Explorer, was split evenly between Bethany and myself, as my father had originally intended before anyone had a chance to whisper in his ear about capacity and windows of opportunity. I did not fight to take Bethany's half from her. I want to be clear about that. My case had never been about maximizing what I could extract. It had been about restoring what my father actually chose, in a clear moment of his own mind, before anyone convinced him otherwise. Rick Alvarez's conduct was referred to the Ohio State Bar Association, and 11 months after the ruling, I received a letter from Priya's office informing me that Alvarez had been issued a formal public reprimand and a 2-year period of supervised practice, after the bar's disciplinary board found he had failed to take adequate steps to assess undue influence despite red flags, namely, Carol Ann's presence throughout the intake and her prior phone call about capacity, that a reasonably careful attorney should have caught. He kept his license. He did not keep his reputation. Feldstein told me, months later, that 2 other estate attorneys in Columbus had begun referring to the case in hushed tones as a cautionary tale in local bar association meetings. Carol Ann and Bethany's civil liability was more direct. As part of the probate court's final order, they were jointly required to reimburse the estate $6,800 for the disputed withdrawals, plus $34,000 in legal fees Priya's office had accumulated over the contest, a cost the court found appropriate to shift onto the party whose conduct had necessitated the litigation in the first place. Bethany, already in the middle of her bankruptcy proceedings, was forced to disclose the judgment to the bankruptcy trustee, which extended her repayment plan by an additional 2 years. Carol Ann sold a small piece of jewelry inheritance from her own mother to help cover her share. I did not feel joy learning that detail. I felt only the flat, tired satisfaction of a debt being paid that was never really about money to begin with. Socially, the collapse was quieter but, I think, more permanent. Word travels in families the way water travels through cracked foundation, slowly, then all at once. 2 of my father's siblings, my Aunt Louise and my Uncle Peter, both of whom had attended the funeral without telling me the date, called me separately within the same month to apologize, having learned the full scope of what happened through relatives who'd heard about the courtroom testimony. Louise cried on the phone. She said she hadn't known, that Carol Ann had told the extended family I'd drifted away after my mother's death and never really reconciled with Dad's second marriage. Another lie, apparently, that had been circulating for years, quietly reshaping how an entire branch of my family understood who I was. I have not spoken to Carol Ann since the ruling. I have spoken to Bethany exactly once, 7 months later, when she called unprompted and asked, in a voice with none of its old composure, whether I could ever forgive her. I told her the truth, which is the same truth I'll tell you now. Forgiveness is something I could eventually offer, privately, in my own time, for my own peace. But access to my life, to my children, to Sunday phone calls like the ones I used to have with my father, that was different. Forgiveness is personal. Access must be earned, and it hadn't been, not yet, and maybe not ever. 2 years have passed since that phone call in the dentist's parking lot. I still have my grandfather's pocket watch, the one my father left me with love, believing, I now understand, that it was the only thing of value he had left to give me, because he'd been convinced I'd already taken everything else I needed and moved on without him. I keep it in a drawer in my study, not displayed, not hidden, just present, the way certain truths sit with you without needing to be looked at every day. The house on Larchmere Drive was sold last spring. I used my half of the proceeds to set up a college fund for my son and to pay off the last of my own mortgage, quietly, the way my father once quietly accepted help from me without ever telling anyone where the money came from. Some mornings I still reach for the phone on Sunday evenings, an old habit that hasn't fully faded, before I remember there's no one on the other end anymore. I've started calling my Aunt Louise instead, most weeks. It isn't the same. It's something, though, and I've learned to let something be enough. I think about my father often, not the version of him that existed in his final confused weeks, believing a lie about a son who never stopped calling, but the version from decades earlier, the one who taught me to check the oil in a car and never raised his voice even when I deserved it. I choose to believe that version was the real one, and that the last few months were a kind of theft, not a reflection of who he actually was underneath it all. So I'll leave you with this, because I think it's the only honest question left. If you found out, tomorrow, that someone you trusted had spent months quietly rewriting the story of your own family behind your back, would you have the patience to prove it carefully, one document at a time, or would you want it settled the moment you found out? Thank you for watching. Everything in this video is fictional, made only for entertainment and reflection, and no real people or events are depicted. But if there's one thing worth carrying from a story like this, real or not, it's that healing rarely comes from revenge, it comes from the slow, deliberate work of telling the truth clearly enough that no one can rewrite it again.